resources that one is referring to without really exhausting the full list of the resources. But I hope I'm indicating exactly what is suggested by that line adequately for the purpose of the Commission.
Thank you, Mr. Jafta. And while we're on this topic, do you recall a secret project of the apartheid regime called Stratcom that was, in the apartheid days, attached to the State Security Council? Stratcom was short for Strategic Communications, and they carried out dirty tricks and specialized operations around deception.
Yes, and I'm aware of certain aspects of it. I wouldn't suggest that I know. I have wall-to-wall knowledge of what Stratcom entailed. And perhaps in that regard, I would have suggested last time I was here that language and its deployment was an important tool. And by way of making an example again, I tried to make a distinction between what was called forced removals and what I consider to be possible to properly profile it as ethnic cleansing, where such obtained, as distinct from forced removals, and that would be part of what Stratcom would have come up with, black on black violence. That would be another product of Stratcom.
So do you think it's possible that elements from the erstwhile apartheid regime could have employed Stratcom-type tactics and projects in the post-apartheid era to pursue their ends?
I have no factual evidence of it, but it wouldn't surprise me that purely what you can call lone wolf operations, somebody would have come from that background, would have pursued an operation that would be quite characteristic of a Stratcom type of an operation. But I wouldn't suggest that post-1994 that would have been carried out within government or in a discernible, organized fashion. Yes.
Yes. So we're also not suggesting that this was an official government operation post-1994. But in due course, we will be submitting to the Commission that the former elements from the erstwhile South African Police, South African Defence Force, State Security Council, that they did employ a Stratcom type of operation to manipulate the approach of government when it came to the TRC cases. And in essence, we will be submitting to the Commission that the deception that they employed was to suggest to senior people in government that the National Prosecuting Authority was on the verge of taking action against the ANC 37, including President Mbeki, and that the underlying rationale was to close down all prosecutions on the basis that if they proceeded against the former apartheid officials, they would then have to move against the ANC leadership. Do you have a comment?
I'm not sure, Commissioners, it is my space to comment on what submission is going to be made. It should be made on the basis of what is available to those who shall make such a submission. And maybe those who have to respond will respond at the time when such a submission is made. I may just suggest, for what it is worth, that powerful as Stratcom was, I'm not sure that it would have played a material role in influencing decisions about whether or not anybody was prosecuted. Further, and I tried to make this point last time, the step around deciding whether or not to prosecute has got to be preceded by and informed by the outcome of an investigation by the South African Police Services or any investigative authority of the state. And a decision to prosecute would be taken to a large degree on that basis, would be informed by a docket. Now, if the submission is going to be informed by the fact of the existence of dockets, and then notwithstanding the existence of dockets, then because of Stratcom, government was then persuaded to try and stop the prosecutions, that's another matter. But that would be my comment.
So just in relation to the notion that you put up about the existence of dockets, there were actually dockets in existence in relation to investigating alleged crimes committed by individuals within the ANC. For example, the landmine campaign. Those dockets existed, and the South African police were pursuing those cases. But by May of 2004, the NPA decided not to proceed with those cases, and they closed those matters. But notwithstanding that decision, certain police officers within the SAPS continued pressing for investigations to go further and for decisions to be retaken. Were you aware of that?
No, I'm not aware of that.
Yeah. You mention, I believe in your evidence in chief, that the approach around the TRC cases had its genesis in the speech made by President Mbeki in April of 2003. And as a result of that speech, government set up an amnesty task team. It was set up by the Directors General Forum, and that team then made recommendations to that forum. Those are set out under paragraph 6.5 of our application. So I just want to put the main recommendations to you for your response. The first main recommendation was to introduce new prosecution criteria in the NPA's prosecution policy to provide additional criteria not to prosecute TRC cases, and that ultimately did happen. Secondly, they proposed a departmental task team which included officials from the intelligence agencies, the presidency, and other executive departments. And then lastly, they recommended that this departmental task team, sometimes called the interdepartmental task team, play a role in advising the NDPP of the advisability of prosecutions in each TRC case before the institution of any criminal proceedings in those cases. What's your response to those recommendations?
Commissioners, perhaps I would need to be advised here. This doesn't come from me, that there was a decision to establish an amnesty task team. I think from what I read, that statement derives from someone else apart from me. And matters related to the amnesty task team would be best responded to by those who were in the constitutive meeting of this amnesty task team and the officials who represented whatever departments were in the amnesty task team. I have my doubts. I would have to go back and look at some material, but I have my doubts about the suggestion that the presidency was represented in the amnesty task team. I seem to think that the presidency was not represented at the amnesty task team, and for that matter was not even represented once the interdepartmental task team was established. The presidency was not represented in that either. So I just thought I must state that at the outset. In respect to what is before me, the application, particularly 6.5.3, where it says, basically it says, if I can read it, it says, his, meaning my view, on the establishment of the task team and its recommendations to the Directors General Forum, including 653, its role on advising the National Director of Public Prosecutions of the advisability of prosecutions in the TRC cases before the institution of any criminal proceeding in each case. If that was provided for, and it is possible it was provided for, that wouldn't fit neatly with the legislation governing the activities and the mandate of the National Prosecuting Authority. I think that would be highly irregular to advise the NTPP on essentially whether or not to prosecute a case. What most definitely would have happened, and I'm saying this on the basis of my experience, having been in the presidency, would be for the departments to collaborate and share information, giving regard to the various differentiated mandates of the departments in the JCPS in pursuit of an integrated outcome, so to speak. I could be wrong here, but 6.5.1 must be talking to the prosecution policy that was established specifically to deal with these matters, that was ultimately set aside, I think, by the Constitutional Court. 6.52, the composition of the departments. I've stated that I have my doubts on whether or not the presidency was represented. As for the other departments, and giving regard to their legal mandates, I wouldn't have a problem with the participation of those departments if one has regard to their legal mandates.
Thank you. Just turning to 6.5.1, the insertion of the new prosecution criteria. Would you agree that this was also somewhat irregular, to put up specific criteria only in relation to a certain class of cases for a decision not to prosecute?
I must restate, commissioners, that this is something that I have no factual knowledge of, that I never participated in meetings of this amnesty task team. So I think that must be borne in mind. But if 651 is talking about the prosecution policy that was subsequently adjudged to have been unconstitutional, obviously then the view that this was irregular would sustain.
Yes, you make reference to the policy that was set aside by the Constitutional Court. It is in fact the High Court,
Okay.
Judge Lehodi, if I understood you.
Thank you for the correction, yes.
Thank you, Commissioner. And Mr. Jafta, just to be clear, we're not suggesting that any of this comes from you or that you were part of the Amnesty Task Team. We know that you were,
Yes.
you were not.
Yes, thank you.
Although you, in relation to the departmental task team that was set up subsequently, some years later, you were listed as a principal member of that team, sometimes called the TRC committee, or the interdepartmental task team.
On the surface, it might appear that I was a principal member. In fact, I was not. I only attended the constitutive meeting of that. I suspect this fact can be, how would I say this? To establish this fact, one would have to look at the minutes of the meetings of the interdepartmental task team and look at the representation. I would imagine that the presidency does not feature in any of the subsequent meetings. The only meeting that I sat in was the constitutive meeting, which I think was chaired by Advocate Pikoli, who then handed over the day-to-day operations or functions or business of that ITT to Advocate Ramaide.
Since you raised the minutes, let's just quickly take a look. Do you have a copy of the cross-examination bundle? It might be that Lever Arch file. Commissioners, I'm referring, Mr. Chapter, to pages 183 and 184. So perhaps we can just start at 183. This is a list of the TRC committee members and then the principal members. It was attached to the statement of Assistant Commissioner Jacobs. So there you'll see the list. We're not going to go through them. And under principals, you're listed in the third row, representing the presidency. And then if we turn to page 184, this are the minutes of the TRC committee meeting, apparently the very first meeting. 12 October 2006, and you're listed as at number 4, representing the presidency. The minutes are there. I don't think we need to go through them. I think you're correct that it was initially chaired by Advocate Pikoli before he handed the chairpersonship to others. I think you are correct that this is the only reflection of you attending that TRC committee meeting.
Correct.
Incidentally, we did pose a question to Dion Rudman, who was a senior official in the Department of Justice, and he was the chairperson of the Amnesty Task Team. And we asked them, why did they recommend that a member of the representative of the presidency be on the subsequent departmental task team, the TRC committee? And it was put to him that this was possibly because this exercise was a project of the presidency, and having a member of the presidency on the task team would help to keep the president informed of developments. And Mr. Rudman agreed with that proposition. Would you agree as well?
Yes and no. The task teams occur in government for a variety of reasons and in respect to multifaceted projects. Typically, reporting or accounting to government in respect to the business of task teams does not, in strict terms of governance, require a representative of the president to sit in each of the task teams. So to suggest unintendedly that that was intended to ensure that the presidency receives regular updates, I don't think that is correct. In terms of the constitutive meeting, the presidency would have had an interest in ensuring that the program of action is defined appropriately and the program of action is outlined appropriately. The operational issues that derive therefrom is not the business of the presidency, and accounting to the presidency would happen whether or not the presidency is represented in such a task team.
Thank you. Can we turn to a meeting that took place at the presidency in mid-2006? And information regarding this meeting comes from the affidavit of former NDPP Vusi Pikoli. And that affidavit is in the same bundle. I'm going to refer you to page 146 of that bundle. Paragraph 31. So I'll just read it into the record so we're all on the same page. So Pikoli writes, I then approached the presidency in order to secure the necessary collaboration of the parties to apply the prosecution policy guidelines. A meeting was arranged in mid-2006 by Reverend Frank Chikani, then Director General in the presidency. The meeting was attended by himself, the DGs of Justice and the NIA, Mr. Selebi, the Secretary of the Defense Secretariat, Mr. Jafta from the presidency, and I. Mr. Selebi again complained about Advocate Ackerman's involvement in the process. Do you have any recollection of that meeting?
In strict terms, no. Would such a meeting have taken place? I would imagine yes, it would have taken place, but recollection in precise terms of such a meeting, no. This is how commissioners, we would often do our work. If, for whatever reason, I picked up that there was a problem, either with the policy or the coordination of a policy or a program, I would raise that with the then head of the policy unit and Reverend Chigane as the Director General in the presidency. And every now and again, when there was a need for that, then he would convene a meeting where the issues that couldn't be resolved would be Reverend Chigane would try to resolve the issues. And paragraph 31 suggests to me that this is one of those issues. That's why I'm saying I have no specific recollection, but what is outlined in paragraph 31 fits in with what would happen in the presidency at the time.
So according to Advocate Bakoli, in his oral evidence, he said that the meeting was called to attend to various problems and challenges, and these included securing investigators from SAPS and then looking at the role of the other state departments on the task team, in particular SAPS and NEO, in relation to the role that they should be playing in the prosecution decision-making process. I assume, of course, this was a long time ago, so that you don't recall those kind of specifics.
Yes, I wouldn't remember the specifics. May I just establish some certainty? I suspect that my reading of paragraph 31 refers to the amnesty task team. That's how I'm reading it. So I just want to be clear that this is what, or is it in respect to the departments that would collaborate in order to give effect to the provisions of the prosecution policy guidelines?
Yes, the latter, not the former.
Okay.
Because by then the amnesty task team had already concluded its work and closed down back in 2004. So this would have been the departments serving on the new departmental task team, or that so-called TRC committee. Let's then turn to paragraph 11 of your statement, where you make reference to a meeting that occurred later in 2006 at the home of Minister Zola Skweyiya, then Minister of Social Development, the late Minister. And this meeting is also referred to in Advocate Bakoli's affidavit. That's at paragraph 32. And I want to read to you Advocate Bakoli's account of that meeting. At this meeting, it became clear that there was a fear that cases like the Chikani matter could open the door to prosecutions of ANC members. I quote hereunder from my affidavit filed before the Ginwala Commission as to what transpired at this meeting. The Minister of Safety and Security was concerned about the decision to proceed with the prosecution and with Advocate Ackerman's involvement in the process, and the issue of whether it was Ackerman or me who was behind the decision to prosecute. The Minister of Social Development was concerned about the impact of the decision to prosecute on the ranks of ANC cadres who were worried that a decision to prosecute in the Chikani matter would then give rise to a call for prosecution of the ANC cadres themselves, arising out of their activities pre-1994. Let's pause there. Can I ask for your comment in particular on the concern raised by Minister Skweyiya that the impact of a decision to prosecute ANC cadres would give rise to a call for prosecution of ANC members themselves?
Commissioners, this is a statement by Advocate Pikoli based on his recollection. There are other people who are suggested to have been present at the meeting. It might be important to solicit their views about what transpired at the meeting. In other words, to test what Advocate Pikoli suggests happened at the meeting. Previously, when I appeared before the Commission, I stated that until this morning, I really was unaware about the existence of dockets that would enable the NPA to decide to prosecute members of the African National Congress in the event the people who had attempted to murder Reverend Chikane were prosecuted. I really am unaware of the existence of those dockets. Now, it seems to me that it is being suggested that the fear was more abstract, if that's the word for it, than really informed by reality. And I find that construct somewhat to be inconsistent with the reality that I have lived. And for what it is worth, I'm going to put it like this. Being involved in the war for liberation against colonial rule and apartheid necessarily attracted adverse implications for those who elected to participate in that war. And such adverse consequences included precisely what was attempted on Reverend Frank Chikane. Now, if those who were involved in the war and the struggle for freedom could then later be characterized as being potentially paralyzed by an abstract fear of prosecutions, when many of them ended up in exile, incarcerated in Robben Island and such other places, I just find that construct to be inconsistent with lived reality. And that's why I suggested that if there were dockets, and I hear the point being made about the landmine campaign, if there was a factual basis that would trigger or cause anxiety and fear, I could engage with that, and I'm unaware of the existence of such. At the risk of repeating myself, I really cannot reconcile with a construct that suggests that fear on the basis of an abstract threat would be sufficient for government with a constitution to then wish not to prosecute those implicated in violations of human rights. I just find that construct difficult to reconcile with. And it would also not be consistent with the fact that the same government made sure, notwithstanding the limitations, or let me put it like this, there is no evidence, leave aside the part of the deal that talks to prosecutions, there is no evidence I'm aware of that anybody interfered with investigative work by the relevant authorities, notably in the South African police services. And if there was an anxiety about prosecutions, I would imagine if the suggestion is that because you have an anxiety about being prosecuted, and therefore you interfered with the prosecution, it stands to reason for me that you would have had the same anxiety if you get to know that there's an investigation, and then you interfere with the investigation. But there is no evidence pointing to that I'm aware of.
So, Mr. Jafta, in short, to respond to Mr. Vani's question, are you aware of the concerns that were raised by the Minister of Social Development with regard to the impact of the decision to prosecute Reverend Chikane on the ANC cadres?
I am unaware of that, and that's why I was suggesting that, and I'm sure it's not for me to suggest to the Commission that this must be tested with the other people who are alleged to have been in the meeting.
Thank you, Chairperson. So, Mr. Jafta, I want to put it to you that this fear or concern was hardly abstract or out of the ordinary, because by this time there is evidence before the Commission that these generals from the apartheid era, through their attorney, a man by the name of Mr. Jan Wagenaar, they claim to have dossiers on the leadership. And the threat that was being made was that these would be released or made available to the prosecutors should their people be pursued. They even claimed that they were in possession of minutes of meetings that had taken place in Lusaka and the like. Furthermore, we're aware of other developments. Not long after the prosecution of the perpetrators behind the poisoning of Reverend Frank Chikane, not long after that of the plea and sentence agreement, a document comprising of a memo dealing with the landmine campaign was actually leaked to the press, to the Afrikaans press, which published it. The evidence of Advocate Ackerman is that that document was forged to give the impression that it was signed off in 2006, when in fact it dated way back into 2003. So given all these developments, I put it to you that this was not an abstract concern, it was a real concern, a real fear of governments at that time.
Commissioners, I would really suggest that this be canvassed with those who are supposed to have had the anxiety. I have read what's in the bundle ascribed to Mr. Wagner. I've heard about people being in possession of minutes of one or the other meeting of some of the structures of the African National Congress in Lusaka. I'm aware that, at least if you're talking about the police, Eugene de Kock was arrested and prosecuted. I'm aware that the people who poisoned Reverend Frank Chikane were prosecuted, in fact, and other functionaries of the apartheid regime, few as they are, but still important. That did not trigger a chain of events that would justify the anxiety that is being talked about. So in other words, the generals, whatever they would have been threatening or suggesting that was going to be their response, I really have no evidence suggesting that whatever they threatened materialized after the prosecution of Eugene de Kock and other people, and including the people who poisoned Reverend Chikane. As a matter of fact, and maybe Reverend Chikane can best explain this, the meetings that he had with the relevant generals, at least in respect to the attempt on his life, I'm not aware that they ever suggested that there was this other option available to them if there was to be a prosecution of the people who had attempted to terminate his life.
Just as a matter of clarification, Mr. Jafta, Eugene de Kock was prosecuted some 10 years previously, in 1996, at a different time when these circumstances were not prevailing. The plea and sentence agreement in relation to Flocken van der Merwe and the others for the attempted murder of Frank Chikane, that took place in September of 2007. Are you aware that shortly after that plea and sentence agreement, Advocate Pakuli was suspended, and part of the complaints made against him was his handling of the Chikane matter? And Advocate Ackerman, who was the prosecutor in that matter, was relieved of his duties in relation to the TRC cases.
I'm aware of Advocate Pikoli being relieved of his responsibilities. I am unaware of the relationship between that decision and how the matter of the poisoning of Reverend Chikane was proceeded with. I'm unaware of that fact. And again, this would have to be canvassed by those who took the decision.
Just lastly, and to be clear, are you disputing Advocate Pakoli's recollection of what the Minister of Social Development said in that meeting?
I'm not disputing it. I have no recollection of him, of Dr. Square having said that, which is why I I then prayed that this matter be canvassed with the other people who were in the meeting.
Yes, we will certainly do that when the opportunity arises. But just to make the point that Advocate Pakoli's affidavit before the Ginwala Commission, he prepared that not that long after these meetings. Let's turn to any recollection that you might have of any further meetings on the TRC cases in 2006 at the presidency. And these are also referred to in paragraphs 34 to 36 of Advocate Pakoli's affidavit. That's pages 148 to 149 of the bundle. So paragraph 34 on page 148, Advocate Pakoli refers to a further meeting that took place at the office of the presidency. That the task team would not make recommendations on a decision to prosecute or not, but it would receive all the necessary inputs and information from the various departments. Paragraph 36, there was a further meeting of ministers in the security cluster at the office of the Minister of Safety and Security. This was attended by the Minister for Safety and Security, Minister of Social Development, Acting Minister Didiza. It's not clear to me whether that's the same meeting he's referring to, although this one was not at the home of Minister Squigia, so I assume it's a different meeting. Do you have a recollection of these other meetings that took place in 2006?
Not in specific terms. Safe to say that my reading of paragraph 34 35 is what earlier we referred to as the minutes of that meeting of the interdepartmental task team. Not unless there is another meeting where Mr. Advocate Ramaite was assigned the responsibility to do this work operationally. So it seems to me that 34, 35, 36 refer to what was the constitutive meeting of the interdepartmental task team. I'm not sure if that meeting took place in the presidency. In other words, at the union buildings. I really cannot, I have no recollection in precise terms of where that meeting took place, but that's my reading of those paragraphs.
Yes, you're partially correct. They were referring to what this task team would do, although that task team had not met as yet.
Yes.
Do you recall in any of these meetings whether there was any opposition expressed to the role of Advocate Anton Ackerman in these cases?
In broad terms, there was I don't know if the word disquiet would explain, but there was a sentiment or some form of unease around the Advocate Ackerman and how he was running the business of government in respect to matters arising from the TRC. Yes, I remember that. But I have no specific detail in terms of what happened in what meeting.
Now, you've made reference to the role of the Justice, Crime Prevention and Security Cluster. And in the documentation, there's reference to a subcommittee of the structure known as the Cabinet Committee on Post-TRC Matters. Were you aware of this subcommittee? And if so, why was there a need for such a Cabinet Committee on Post-TRC Matters?
Commissioners, and I mean this with the greatest respect, I was not a member of cabinet, much less the head of the national executive. The decision to establish subcommittees of cabinet rests entirely with the head of the national executive, who was the president. And that was Mr. Thabo Mbeki at the time. I was not the spokesperson of cabinet at the time, and I think I cannot express an opinion on matters that fell completely out of my province, outside my province. This is a matter that is best left or canvassed with the head of the national executive and cabinet.
Let's turn to the TRC committee, or the interdepartmental task team that was set up as a result of the recommendation emerging from the earlier amnesty task team. And we know that it had its first meeting, I believe it was October of 2006. Can I ask how it was that you came to sit on that committee, or at least that first meeting? Who appointed you?
As part of my responsibilities in the policy unit, I sat in meetings of ministers, with DGs, or rather with ministers, or of ministers. I attended meetings of committees of the JCPS and subcommittees. All of that did not require a prior specific appointment to attend a specific meeting. And I would suggest that, in fact, I don't think there was a set of rules or protocols that governed which task team one would attend and what regulatory instruments one would satisfy before one attended. So I attended this specific meeting in the normal course of one discharging his responsibilities, as I had outlined right at the beginning about the mandate and the functions of the policy unit.
If I can draw your attention to your statement, 11.1.2, and actually we're going back to something that you say emerged from that meeting at the home of Dr. Skwiyiya. You mentioned that a proposal or idea in order to finalize cases arising from the TRC, two prominent individuals, one from the apartheid regime and the other from the ANC, could be identified for prosecution. In this way, I understood any party to the conflict over apartheid would not feel more prejudiced than the other side. This would have been raised as a point of principle, and no names of people were mentioned. Can I ask who raised that proposal or idea?
Commissioners, 11.1, maybe let me read it to the record. 11.1 reads, I attended several meetings that dealt with matters related to the work and report of the TRC. I also was in attendance when a meeting took place at the residence of the late Minister, Dr. Z. Square. Although I have no specific recollection of the specific details of what transpired in the meetings referenced, I broadly recollect the following. 11.1.2. A proposal had emerged, a proposal or idea that in order to finalize cases arising from the TRC, two prominent individuals, one from the apartheid regime and one from the African National Congress, could be identified for prosecution. In this way, I understood any party to the conflict, that would be the former regime and the ANC, would not feel more prejudiced than the other. In other words, there would be parity on how the two parties to the conflict were dealt with. This would have been raised as a point of principle. In other words, a proposal or some idea, informal, and no names of people were mentioned. The last time I appeared before the commission, I indicated and I spoke to this point that at some point, there was a view that emerged that in order to bring matters arising from the TRC and its processes, it perhaps would be prudent to identify two prominent individuals from the apartheid regime and two prominent individuals from the ANC. I then explained that this was found to be seriously problematic for various reasons, one of which would be that an approach such as that, and I have no recollection of where this came from, but it certainly did receive attention. An approach like that would put on the same pedestal those who were fighting for apartheid and those who were fighting against apartheid. And this was found to be objectionable. And I did explain something that I referenced earlier, and maybe let me repeat that. I think it's 1973 when the United Nations pronounces apartheid as a crime against humanity, which it was. And that kind of an approach would fly in the face of that resolution by the United Nations. I did indicate earlier, like I did the last time I was here, that there were particular problems with the deployment of language, such as referring to ethnic cleansing, instances of ethnic cleansing, and then you refer to that as forced removals. So for those reasons, it would be really, it was argued, it would be very, very wrong to put on the same pedestal those who were fighting for apartheid and those who were fighting against apartheid. And I'm making the point at 11.1.2 that this had received attention. Whether or not it was specifically at the meeting at the house of Dr. Square or some other time, I do not know in specific terms, but this is something that did receive attention.
Thank you, Mr. Jafta. As a matter of interest, I would agree with you when you say that this tit-for-tat approach would have been a simplistic way of developing an approach to deal with apartheid-era cases. And coincidentally, around that time, I made a written proposal to the NPA advising against a tit-for-tat approach because it wouldn't take into account the context of apartheid and the fact that under apartheid thousands of people had been prosecuted and persecuted for their political stands. So that context is important. On that score, we're on the same page. Before we close up, I just want to make sure that I think I've covered almost everything in your statement, but I'm now turning to my notes from your evidence in chief. And I just want to see, I think we've covered almost everything. In your evidence in chief, you mentioned that one of the reasons for the approach adopted by government was to help uncover the networks and find information about arms caches and the like. And for that reason, government came up with this new approach to TRC cases. My response to you for your comment is that government was always able to do that. It had the necessary tools, it had its intelligence services, and of course in the criminal procedure, it had Section 204 where it could indicate, it could use state witnesses, and if they testified honestly, then they would be granted immunity. So I put it to you that the rationale that this approach had to be adopted for the TRC cases was something of a fig leaf. It was a justification put up in order to control the cases rather than to extract that kind of information.
The matters arising from the TRC are complex in the sense that at the one level, you would have to deal with the absolute operational functionaries. And these would be the people who would know where the body was buried, who pulled the trigger, who bent the body, how was it disposed of, where are the caches. At another level, you have to engage with those who formulated the policies, who gave the authorizations. So yes, these are matters that have received attention even prior to 1994. And dare I say, these are matters that should continue to receive attention. And it is almost like that universally in respect to transitions from totalitarian regimes to a democratic state. So yes, that was always the case. But in respect to these matters that arise from the TRC, they provide yet another opportunity for, if the departments work in a mature way, the police, the intelligence agencies, and such like, for them to exchange information, because in one case, make an example, in case X, you may find information that sheds light on something that is yet to be resolved on a completely different set of matters. And so there is never a time where you can, with a hard and fast rule, say, now there is no fit or relationship between what had happened before and what's happening in respect to the TRC cases and what happens subsequent thereto. This is an ongoing modus operandi, so to speak, because whether you're dealing with terrorist organizations, transnational criminal syndicates, you need this collaborative approach between the various entities that are responsible for the administration of justice and other responsibilities of the state.
Thank you. Also, in your oral evidence, you said that you were unaware of any attempt or effort to stop the law enforcement authorities from carrying out their legal mandate. Were you aware of the direction that then Minister of Justice, Bridget Mabandla, gave to the then acting NDPP, Silas Ramaita, in November of 2004, a direction that the TRC cases should not be pursued further until the development of guidelines to handle those cases?
I was unaware of that, Commissioners.
And
I remain unaware of it. Yeah.
right. And were you aware of the struggles that the NPA had in securing investigators for these cases, a struggle that persisted from 2003 all the way to 2010, which effectively meant that apart from a few cases that had been previously investigated, and we're talking about a handful of cases in that regard, they were not able to pursue these cases because they were simply denied investigators until halfway through 2010.
I did state, Commissioners, that there are other challenges that would have attended investigations in respect to the security apparatus of the government that obtained prior to 1994. And I did say that although there was great and mature collaboration between the various entities, the operations were still nevertheless very, very compartmentalized. In other words, they were underpinned by the doctrine of need to know. And for any investigation to succeed, you would need to secure collaboration with evidence from those who were within a particular unit that would have carried out an operation. This would not be an easy matter. I was aware that, and I'm even, having read this document, I'm more aware now that the police are supposed not to have availed the sufficient numbers of detectives, as an example, to do investigative work. But that's a matter that really ought to be canvassed with the police, having regard to a whole range of other factors or variables that obtained within the police, such as the number of detectives, the number of crime scene experts, capacity with the forensic science laboratories, etc., etc. So there's a whole number of other variables that would have to be looked into, and regard would have to be had to such other matters, such as the case cycle times. In other words, between when a case is registered with the police in a police station and when the case is ready for a decision on whether or not to prosecute, whether the variance between normal detective work was so different in respect to detective work attending matters arising from the TRC. So that's what I suggested last time around, that it might very well be that if somebody looked into that, you might find that the cases arising from the TRC, which is bad, are typical of normal detective work, material outputs of detective work in the police. But I do not know for a fact if that is the case.
Chairperson, I see it's almost 1 p.m. And looking at my notes, I estimate that I will probably need another 15 to 20 minutes. So I just wanted to check with Chairperson whether you wish to proceed or adjourn for lunch.
For 15 minutes, for 5. Should we continue with him or don't feel safe? Mr. Vani will continue until you complete your cross-examination.
As the Chairperson pleases. Mr. Jefta, also in your oral evidence, you mentioned that Frank Chakani had made various complaints about the role of the NPA. For example, that in a meeting that Advocate Ackerman had with him, Ackerman, to use your words, berated him, and he complained further that the NPA should have consulted with Reverend Chakani before the plea bargain with the perpetrators went ahead. So I just want to put it to you that under oath, both advocates, Anton Ackerman as well as Mthunzi Maga, who were present in that meeting, deny that version. And in relation to the consultations, advocates Bekoli and Ackerman assert that they consulted with Reverend Chakani on multiple occasions before the plea bargain. Do you have any comment on that?
Commissioners, I reported on a conversation that I had with Reverend Chikane. To be very precise, he could not have complained to me. He merely shared with me his experience of the meeting. If it is necessary, I will repeat that. As far as I can recollect, it is Advocate Pikoli who called seeking an appointment with Reverend Chikane, which request for an appointment was granted. And instead of Advocate Pikoli showing up for the meeting that he would have requested, it is Advocates Ackerman and Maga who showed up at the meeting with no suggestion from Advocate Pikoli that he was no longer coming to the meeting, but instead was sending the two officials from his office. I do have a recollection, not very vivid, that Reverend Chikane was quite distressed at what happened. It might be of benefit to the Commission to contrast what Advocates Maga and Ackerman say transpired at the meeting with what Reverend Chikane would say. And I do not know if he has canvassed this matter with the Commission. What I also stated was, in line with what Reverend Chikane said to me, shared with me, I would have expected that perhaps maybe the NPA could have explored exchanging notes with Reverend Chikane on what it is that he would have gleaned from his engagements with the people who tried to kill him and the supervisors of the people concerned. My recollection is that no such an engagement took place, but it was more like, what are you talking to these people about? Desist from further engagements, and if you continue, some penalties would attend such behavior. That's what I recollect, and it would be interesting to test the assertions by Advocates Maga and Ackerman against what Reverend Chikane would say about his own experiences.
Yes, just for the record, Advocate Pakuli testified that before that meeting took place, he had already met with Reverend Frank Chikani. But let's move on to what you testified in relation to a discussion you had with Advocate Menzi Simelane, who made some complaints around how the NPA at the time was dealing with plea bargains. And if my notes are correct, you indicated that Advocate Menzi Simelane was of the view that some of the perpetrators should have been given plea bargains in order to assist them to testify against other accused. Now, if that recollection is correct, then I must put it to you that that's not what plea bargains are designed to do. A plea and sentence agreement is in fact an agreement between the accused and the state as approved by the court. They're not then required to testify against other accused. There's a separate section dealing with that section 204, which does allow for state witnesses to give testimony in exchange for immunity if they testify honestly. Do you accept that?
I accept that, and I must repeat what I said, that I wish that I shouldn't be requested to elaborate on what it is that we're talking about. It was by way of making an example, and I can assure the Commission that the matter we're talking about had absolutely nothing to do with the Truth and Reconciliation Commission. Absolutely nothing.
And later in your oral evidence, you mentioned that prosecutions against senior figures in government, which might require them to step down from office, could paralyze government. And when you were asked, I believe, by Commissioner Gabriel whether that was an academic notion or a real threat, you said it was in fact an actual threat. So what I wish to put to you is, given that it was an actual threat, surely that then adds to the assertion that the families make, and that this threat did feed into the concerns held by government and help to shape their approach to these cases.
Commissioners, the matter arose somewhat differently. Whether or not prosecuting, and as an example, the 37 members of the ANC would constitute a threat to national security. And the point I made was that theoretically, if you were to prosecute, as an example, if you make an allegation against a sitting president with a view to prosecute, it would stand to reason that that president would have to step down and leave the office of president for very, very obvious reasons. Now, why was this? This was not canvassed by me to suggest that this was an anxiety that would have caused government to interfere with prosecutions. I restate that I'm unaware of an instance where government interfered. The point made earlier about Minister Mabandla corresponding with Advocate Ramaite was unknown to me. The point about it is, theoretically, you can have a scenario where, suppose, theoretically, you mount a prosecution against a president and several ministers on account of them, in this particular example, having been members of the National Executive Committee of the ANC. You can paralyze government. Particularly where you can so mount such a prosecution with a reasonable, within reasonable bounds that in fact there might be no successful prosecution. And that is very, very possible. So in that case, yes, that would undermine, that would cause a president. But it has no bearing. I restate the points I made earlier, that I'm unaware of investigations, I'm unaware of dockets that were referred to the NPA for prosecutions, and I remain convinced that no such an anxiety existed based on any facts.
Right. Well, on that score, I'm sure you're aware that we will be submitting to the Commission that there was this anxiety. But may I refer you to what you said in relation to your role on the interdepartmental task team? You had an exchange with Advocate Seme, that you attended the constitutive meeting, and you said the following. It wasn't clear to me whether it was about the ITT or other meetings. You stated, "Now, I have just said I attended many meetings. Does that mean I was operational? No. But I was close enough to know what works and what does not work." Can you explain what you meant by saying I was close enough to know what works and what does not work?
Commissioners, this arose when I was making an example about a visit I was a part of to the borderline between South Africa and Mozambique, where on a particular day of the week, and I don't know which week it is, the same communities separated by a fence now are Mozambicans on the other side and South Africans this side. And there's a market day, and they trade on all manner of goods, tobacco, alcohol, small animals, goats, etc., with the borderline at the time being patrolled jointly by members of the South African Police Services and the South African National Defence Force. And adjacent to that specific area, there were reports that syndicates or members of criminal syndicates from Mozambique would steal sports utility vehicles from the South African side and simply speed into the fence and drive into Mozambique with such. And the legal system on the other side of the fence made it almost impossible for such vehicles to be repatriated back to South Africa. So considering all the facts around managing security along the borderline, I would know what works and what doesn't work. That arose in that context. Now, you can extrapolate and say what I was suggesting, which is true, is that in respect to quite a wide range of other issues within the purview of the JCPS, I would know what works and what doesn't work. simply because and this is not just true of Loyiso Jafta, it is true of the other colleagues in the policy unit who were responsible for the other clusters, because you needed to keep your finger on the pulse of what it is that works and what it is that doesn't work. And that arises from the monitoring and evaluation function of the policy unit.
So yes, I recall that exchange. It was actually in a response. It was a question that Advocate Sema put to you after you had said that you were involved in lots of task teams, not just this one. And she said yes, but you did not get involved in every instance of crime. And then you gave the example of the issues that arose on the Mozambican border. So yes, and that's obviously a very legitimate exercise to try and work out what will address those issues, what will work, what will not. But I want to put it to you that that kind of work is very different to a task team that involves itself on a case-by-case basis as the interdepartmental task team did. And in fact, there was a point where the representatives from SAPS and NIA insisted that before the NDPP could act in any case, he would need to wait for a recommendation from the task team and indeed the DG's forum. Would you agree that there's a big distinction between that example and the task teams that deal with issues that arise, for example, on the Mozambican border?
Absolutely, but commissioners, I would also want to, and I'm not nitpicking here, please don't misunderstand me. The reference to NIA and the police asserting that they would have to advise the NDPP, actually in the minute that was referred to earlier, that in the minute that ascribes that matter to have been raised by a member of the Directorate of Special Operations, DSO, and not NIA or SAPS. But the commission can go back to the minute. But my recollection is that that matter, in principle, I agree, it is wrong. But factually, at least as far as the minute is concerned, that matter was raised by a member of the DSO and not a member of either the police or the... It's just that I don't want to distract the commission, but that matter was raised by a member of the DSO.
Yes, Mr. Jafta, can I suggest we don't go into it, because we're not relying on that minute to make that assertion. There's other documentation, and indeed there is a letter to that effect addressed from the then Commissioner of Police, Salebi, to the NDPP,
Okay.
setting that out, which then caused a crisis, because that was a bridge too far for then NDP Pikoli. It then caused him to write a memorandum to the Minister of Justice, setting out his concerns that his office, the independence of his office, was being undermined. If you like, I can find those documents to put to you, but do you accept my word that that is in fact what happened?
Commissioners, I've just stated that in principle that would be wrong, whether it is by the late Commissioner Salebi or by the member of the TSO. In principle, that would be wrong in law.
I'm just skipping over questions that I believe we have canvassed already. Yes, perhaps one last question from the oral evidence. Commissioner Gabriel put a question to you as to why nation building was at odds with the TRC process, and in particular in relation to the prosecution of the cases emerging from the TRC. And in relation to the pursuing of cases where amnesty had been denied, and your response was these were very complex matters, and you gave various examples of what had emerged from the TRC that needed to be addressed. But in relation to the prosecutions, you said this was not a problem if done in the spirit and letter of the law. Or put differently, if it was not done in the spirit and letter of the law, it would be a problem. What did you mean by that?
Let me go back to my conversation with Reverend Chikane. I genuinely believe that he felt aggrieved by how he was engaged by the team from the National Prosecuting Authority. And I'm not suggesting for a minute that you can then use that and generically say that is how the NPA would deal with all other matters. But the point that I was making there is that you have to implement, and that goes for almost any other business of government and not just TRC cases, implement it in accordance with the spirit and the letter of the law. And I did say prosecutions of themselves have absolutely no bearing on national security. I did state that.
And then finally, there is evidence before this commission that post the winding up of the TRC, although there were initial efforts to follow up the TRC cases, the ones that had not been amnestied, as we stand here today, more than 20 years later, very few cases have gone ahead, which is really the reason why this commission is now sitting and investigating. Do you have any comment on the fact that so few cases have proceeded since they were handed over to the NPA some 20 odd years ago?
Commissioners, I wouldn't want to come across as being insensitive to matters arising from the TRC. Far be it that would be the impression. The matters arising from the TRC are multifaceted, and I know that this commission is dealing principally with the investigations and the prosecution of those matters. I could be wrong, but I suspect that, yes, for a start, I wouldn't be satisfied that so few cases have been concluded through a prosecution. But I suspect that in respect to other matters arising from the TRC falling within the remit of other structures of government, you are likely to find the same kind of unacceptable pace. Restitutions, and a whole range of other issues, looking for and extracting, exhuming the remains of people who remain unaccounted for. There is real pain. I should, in all honesty, apologize for this. I did talk about my personal circumstances, and I should not have, because I don't want to raise the personal circumstances of my parents as though that was the most important thing, or I'm abusing sitting here to elevate that matter.
Yes, but you don't have to apologize for that.
Yes. Thank you, Commissioner. But the truth is, the point one is trying to make is that it is very, very possible that what you find as an outcome, and possibly the impact of government interventions on matters arising from the TRC, you may find the same kind of outcome or outputs in respect to a wide range of other issues. Maybe perhaps with the exception of the change of place names, Port Elizabeth to Gqeberha and that sort of a thing, you may find that there's an appreciable spike on that level. But otherwise, I have my doubts about what government has done. I have to raise this as well, commissioners, that truly, if you were to ask for my opinion, there is no greater restitution for matters arising from the TRC than the attainment of freedom itself and the constitution that we have that should ensure that such abuses never recur in this country. The greatest thing that has happened to the people of this country, outlined in the constitution, is the greatest thing that South Africans have achieved to put an end to colonial rule and apartheid. That's what I would want to end on.
Thank you, Mr. Jafta. I think we can certainly agree with you on your last point. But in relation to your assertion that the failure to proceed with the TRC cases over all this time is similar to the failure to deliver in a range of other matters, I think there we would have to disagree with you. So, for example, the work of the Missing Persons Task Team, they've done amazing work, actually. They've recovered a large number of bodies. They have returned remains of missing people to their families, and they've assisted them to restore dignity in all those cases. So that's an example where there has been significant delivery. And I'd like to put it to you that they were able to deliver because no obstacles were placed in their way, but obstacles were placed in the way of the attempts to achieve justice in the TRC cases.
I honestly have I wouldn't want to comment on that. Yeah.
Chairperson, my 20 minutes is up. No further questions.
Thank you.
Mr. Jafta, one aspect, if you can go to paragraph 8 of your statement, reading more or less from the last sentence, some of the findings and recommendations fell within the mandate of the departments that make up the JCPS, which is the Justice Crime Prevention Cluster. And then 8.1 says that, some of this related to the following. 8.1, trying to determine the remains of people who remain unaccounted for, which is incidentally an aspect that you have touched on. On the 9th of June 2020, there was an interview by a journalist of Starter with Mr. Wagner, who represented generally the security forces, or some of them. And Mr. Wagner suggested there was this impediment, and if you could go to page 49, red number, 31 of the interview.
Page 41.
Page 49, 49, red number, and it's 31 of the, or maybe page 10 of the interview, or
Yes.
black number 31. There are 3 numbers.
Yes.
Each one could take you there. Have you found it?
Yes, yes, Commissioner.
Yes. Now, I just want to read this to you, what Mr. Wagner says about the impediment, particularly of the recovery of some of the bodies of the missing people. He says, if one reads from more or less line 6, he says there, and then I said to her, in other words, to Dr. Jobson, because my memory serves me right, I said to her, but let's suppose those missing people were murdered by the security forces. I think it was at that discussion, I'm not sure. I think then I said to her, Dr. Jobson, that suppose that was the case, you can't expect those people to come forward and say, we killed someone and we buried him there and there and there. If you merely want the remains because there is no legal privilege attached, I think that that is what I said to her that day. You need a process where there is legal privilege. And that directive, that prosecution directive, created a situation of legal privilege. And down there, he carries on, yeah, I said to her, but you people, you were the people who took that thing to court to have it declared unconstitutional. And I think that that was an opportunity missed. Now, if you take what you have said at 8.1 there and what Mr. Wagner says here, let me ask first, did we at any stage have maybe met Mr. Wagner and if you at any point discussed something along these lines with him?
Commissioner, I never met with him, and therefore I never had a discussion with him on these matters.
And now he says, if I understand him correctly, the reason why some of the missing people that were murdered by security forces, their remains have not been recovered, is because of what, let's just say, basically the Galata group or whoever or maybe the Ms. Similani who took this matter to court. In other words, if they did not do so, the remains of these people may have been recovered. What do you say about this attitude? I don't think he's speaking his mind. I think he speaks on behalf of his clients.
Commissioner, thank you. It speaks in part to a point I had made earlier. There are people who were captured by the security apparatus of the former regime, tortured, and their remains disposed of. There are cases that are known, and there are cases that may not be known, because there are people who would have been intercepted, tortured, and killed because of mistaken identity. So it's not always the case that people refer to here will all of them in all circumstances be activists. Now, the operatives who would apprehend a person, torture him, and get him killed and dispose of the body would not be a very large number. In order for you to get to the nitty-gritty of the detail, one of them has to come forward, one way or the other. The circumstances will vary from one case to another. There are examples one can make mention of. There are people who were apprehended. We know that to be fact. And they are not accounted for. But you know the police station where they were last in some form of detention or custody of the state. Typically, when somebody went into the custody of the state, say in Lady Brand or a place such like place, almost always bordering one of the neighboring countries, you can make an entry into the investigation through there. You would know who was the officer commanding on duty on the day. But then the obstacle would be to get to the actual functionaries who can take you there. That's one level. But you need the enablers of this kind of an operation, and that's where you have to go to the policymakers and those who approve the operations. My experience is the operatives, and particularly their supervisors, at a policy level and other levels, say at the level of an accounting officer, I don't think they were ever keen, and this would vary from one department to the other. I don't think they were ever keen on the very project of transitioning from apartheid to democracy. And because of that, you are going to find varying degrees of a willingness to assist the country to resolve, in the case of what we're talking about, this specific matter of people who are missing. You will make a bit of success with a Eugene de Kock because of his specific circumstances, and he can help you. But anywhere else in the security apparatus, civilian or military, where you don't have a Eugene de Kock in that environment, you are not likely to make a lot of progress. Were they not cooperating as a collective? To be sure, they were cooperating. But there were such strict rules that governed who knew about which operation. And this attitude that is displayed here, you will find it almost across the spectrum. You'll find it across the spectrum. It is remarkable that the identities, the names and the faces could be matched to the people who poisoned Reverend Chikane. It is not always the case that you can do that, where you can match a face and a name to a particular incident. It is exceedingly difficult. There was an incident, commissioners, where I chanced upon a fella who didn't look well, somewhat inebriated, heavily, in fact, not somewhat, who with absolute glee talked about how someone I knew personally had been shot dead. It's an extrajudicial killing. And I went back, you listen, and you listen, and you listen, and then you go back and you talk to the people charged with this responsibility and say, but there's a chap who was inebriated, boastfully talking about how somebody was killed. So we went back. I don't think we offered him more brandy than already was in his system. But he was quite incoherent. But I have no doubt in my mind that if we spent a little bit more time with him, he would have taken us to the detail of what happened. I'm extremely hesitant to say what I'm tempted to say now. Because it might come across as being opportunistic or insensitive. You can think about Mtlenge and how he was killed. A lot happened. I think some of you know Justice Shabalala and his wife. I could be wrong. I don't think that matter has been resolved. Yet it's not a crime that happened in a remote place at 2 a.m. in the morning. I think his wife was killed very, very brutally in such a manner that that matter could have been resolved in the same way. So there are many of these kinds of cases. I may as well abuse my being here. I think President Mbeki himself lost a child and maybe another sibling to the same kind of. And these are mere examples. There are numerous other families spanning generations who have got this wound that will never heal.
Yes. Let me ask you perhaps an unfair question. It may be said, qua vadis, where to from here, particularly for people who have lost loved ones, to try and, find more of these missing people killed by the forces and so on. Where to from here? That's unfair as a question.
Yes. Commissioners, this is not a theoretical conversation. It helps to highlight the importance of this work, just this one, as an important pillar for the transition into a young democracy that is maturing. I am aware of some efforts that are being made, and maybe it should be that such efforts must be given more resources, broadly defined, to put a bit more effort into this work. The typical answer, which is implied here on page 49, is that those who were involved have got this anxiety that if they so disclose, such a disclosure is going to attract a legal process with adverse consequences for themselves. But there must definitely be more effort and resources invested on this work, because many of these people who did these things are still alive. Many of them are still alive. But the number is decreasing, and the memory as well, and the markings on the graves move as well. And some of them were not really, I'm thinking about a particular case now where the person was a gardener, really. The person was a gardener, working in the garden, attending to the gardens, but was just beloved by this official. And the person would talk about how they would smash the skull of a person in custody and dispose of the remains. Such people you can have conversations with such people, but the difficulty is, how do you give an assurance that once such a disclosure is made, then you shall not be prosecuted?
Yes. Are you through? Thank you, Mr. Jafta. Thank you, Chair.
Thank you. Ms. Seme?
Thank you, Commissioners. I just have one issue that I want to converse with you. It's on the ITT. You are aware that there were further meetings of the Interdepartmental Task Team, apart from the constitutive meeting.
Yes.
And you did not attend those meetings.
No, I did not.
Commissioners, it's not part of the bundle that Mr. Vani provided, but in Mr. Jacobs' affidavit, I'm trying to check on my notes, and I did make the note, and I want to place it on record. That a meeting took place on the 25th of October 2006. It's PCJ4 of Dr. Jacobs' bundle at page 1721. There are minutes of that meeting. You will note that Mr. Jafta is not present in that meeting. Again, on the meeting of the 6th of November 2006, PCJ6, page 1735 of Mr. Jacobs' bundle, a meeting of the ITT takes place. Mr. Jafta is not present. The further meeting of the 16th of November 2006 at page 1750, ITT meets, Mr. Jafta is not present. The last one again on the 4th of December 2006, PCJ 10, page 1752, Mr. Jafta is not present. I haven't noted the one that took place in January 2007. Again, in that meeting, Mr. Jafta is not present. And can you comment on why you were not present in all those meetings?
Thank you. Commissioners, I would not have attended because those would be what I consider operational meetings. It's actually the task team doing the work, and I would not attend that meeting for that reason.
Thank you, Commissioners. That is all I wanted to place on.
Thank you. Mr. Jafta, we wish to express our gratitude for your attendance at this commission to give evidence before it. You are now excused as a witness.
Thank you.
For attending. These proceedings are adjourned until tomorrow at 10 o'clock.
We're going back to the Specialized Crimes Court in Pretoria, where Griselda Lewis is. And you heard her earlier looking for the NPA spokesperson, Kaiser Khanyago. Well, she has found him. So let's take you back to Griselda.
All right, let's hear questions being asked from the media. So we'll take this one live.
The NPA IDAC had been hoping for. This essentially means that the whole pre-agreement that you reached with the defense has collapsed.
No, thank you very much. And definitely it has collapsed. Obviously, there's a ruling now that the pre-agreement is null and void. And we really have to accept what the court has indicated. Obviously, it was not within our control as we had agreed. And then there was a change of sentence. And they had the right, obviously, in terms of the law, to either agree or not agree, which they did not do today.
This essentially means, Mr. Khanyago, that you have to go back to the drawing board. Anything that was reached in that plea agreement, including what we understood from this court, was an affidavit which contained the names of very senior police officers who are alleged to have also been involved in this rogue tender. You cannot use that anymore. You go back to the drawing board. He then also has to join the other accused now who have been appearing in this matter. Clarification there.
Thank you very much. Yeah, definitely, because now the plea has been deemed to be null and void. Nothing that was in that plea can be used. Therefore, we have got to continue with our own investigations from IDEC side. And then, obviously, the matter will come back here on the 11th of September. And what will then happen is we'll then ask for the court to then rejoin him as accused number one in the other case so that he can now be tried. Because by not accepting the plea, he's basically saying, I will want to go full force with the trial. Therefore, that's what is going to happen.
Mr. Khanyago, Slindo Lesibata from ENCA, how confident is IDAC with the investigations and the evidence you have so far? I mean, this plea deal was certainly going to be a win for the National Prosecuting Authority. It's null and void. You can't use anything he said in his statement. How far are you with the investigations of those he did implicate in his statement?
Yeah, obviously. You would know that our matter in the other case was not dependent entirely on the plea because we had already arrested people who were involved in this, and therefore we arrested them on the basis of the evidence we have against them because we would not have done that. Therefore, the plea agreement came after. It was just to add more people that were going to be mentioned in the plea. Therefore, we'll do our own investigation and then get our own evidence. If it leads to all of them again, therefore, they will be arrested as per the way we did with the other ones.
Mr. Khanyago, Veronica Makhwadi here from Newsroom Africa. The question that I have is, And perhaps you'll take us into your confidence. It seemed as though Matlala was willing to play along with the state when we initially, of course, got into this plea agreement. What's the reason behind the U-turn, and do you fully believe that he is comfortable with this particular decision? Because it seems as though from the atmosphere that we got in the courtroom, when his lawyer, of course, joined in on this matter, a lot of the situation suddenly started to change, if you will.
No, we all of you were here and you could see what was happening in the previous one and even now. But obviously we don't know what is happening behind the closed doors somewhere. Therefore, we will just take it as it is. That's why, if you see, the magistrate doesn't only take what the lawyers are saying. They've got to confirm that you, as the accused, agree. And that's what was important. And therefore, we really do not want to speculate on what the reasons might be. We had a deal arranged and finalized. The only thing that changed was the sentence. Therefore, we expected him to accept it, but we don't know what would have happened behind closed doors.
Do you felt as though that he was willing to comply? I mean, he did initially plead guilty to those 7 counts.
Yeah, definitely we thought. Obviously, we wanted that to happen because we wanted to move and finalize this case. It's not only because of the people that we going to get, but also it will reduce the time to deal with this matter, because now we don't have to go all the way and then deal with this matter. It will be in our interest that this matter is finalized quickly. But now it means we are going full force with the matter, and then obviously we will see how it goes.
Mr. Khanyago, this is certainly quite a big blow, because you would remember that the presiding magistrate, in handing down that judgment, basically spoke about Mr. Matlala being the kingpin, having done this out of greed. He was the chief orchestrator, if I can, of everything that happened. He started the process. He was the one who paid gratification to other individuals who've now also been dismissed from the South African Police Service. So this is quite a blow in that the main man, I would say, that the NPA was looking for, and you believed that today would bring some finality to the matter, basically bombed.
It is a blow in as far as the police concerned, but not in as far as the matter the case is concerned, because you must remember, because of all of those things that the magistrate said, he was already accused number 1 in the other case. And that is purely because we believed even there that he's the mastermind behind the whole thing. That's why it is the other cases, Matlala and others. Therefore, we still have evidence against him, and he knows that we have got the evidence against him, and that is why he's accused number 1. And we are saying, let's go to the other matter and then make sure that we get conviction on that matter.
Mr. Khanyago, last question from me. Do you believe there may be some behind-the-scenes workings that might be taking place? And I'm going to ask this simply because you were confident that this matter was going to reach some kind of finality. There is this damning affidavit, which we understand from this court contains the names of higher ranking police officials alleged to have been involved in this rogue tender. Do you believe, as the NPA, that there are some behind-the-scenes workings, perhaps? We've heard the words higher-ranking police officers.
It's a very difficult one for me. Whatever I believe or not believe, or the organization believe, doesn't matter, because at the end of it all, the person who was asked the question in court was him, and he said he is withdrawing. Therefore, we cannot just assume that he's withdrawing for other reasons than what he believes in.
Right. So, Mr. Khanyago, there were no discussions. I mean, since the last appearance over the 2 weeks, what the nature of the discussions? Because the understanding was that you were going to interact with his team and maybe come to some conclusions.
Yeah, obviously there has been some engagement, but it would not have been as we wanted it to be. We arrived in this court not knowing what the decision is going to be. We were also as shocked as everybody else, therefore, but it comes with the territory. And that's one thing that people need to understand, because, for example, I was reading somewhere where somebody was saying, oh, you need to withdraw this plea, because of other things happening at Madlanga. Our court systems are very clear. We do whatever plea, but it is not final until it is finalized by a magistrate. Therefore, when the magistrate hears this matter, decides whatever, makes suggestions, and it comes to this, obviously there's nothing we can do if the other party withdraws, because when they withdraw, it means the agreement doesn't happen. It's only us who remain in the agreement, therefore it cannot be.
Mr. Khanyago, Mr. Matlala is expected at the Commission on Wednesday, and this particular tender is certainly going to be discussed at length. Is the NPA comfortable with Matlala going to the Commission to discuss this matter that is clearly still sub judice, or can we anticipate the NPA going to make representations at the Commission?
Yeah, obviously, we cannot tell the Commission what to do. They can ask whatever question that they want to ask, and especially now under the circumstance when we have got this plea now being null and void. Therefore, I think they will do what they're supposed to do, and we will go if we are needed to go. But for now, we leave it to the Commission.
Thank you so much.
Thank you very much indeed. That was Kaiser Khanyago, who is a spokesperson of the National Prosecuting Authority. Quite a disappointment for the NPA, who were really expecting to close off this matter today. But unfortunately for them, hearing in court, of course, that there is absolutely no deal. Kat Matlala, Vusumuzi Kat Matlala, now having withdrawn from that plea agreement. You'd recall, of course, initially, when the defense and the state had reached an agreement, they'd agreed for an 8-year direct imprisonment for him. And the reason why the state had agreed to this, because they felt that this damning affidavit that Matlala had deposed of had contained the names of higher-ranking police officials who were alleged to have been involved in this rogue tender, and the state believed that in exchange for that information, a lesser sentence, which would have been that 8 years direct imprisonment, would suffice. Unfortunately, this court found that that was too lenient, adding 4 years and basically saying, put the proposal to a 12 years direct imprisonment. Vusumuzi Kat Matlala, of course, had been mulling over that since the last court appearance. He arrives at court today, pulls out of that agreement, which essentially means that he is now going to go back and join the other accused, you'd recall, that also include the suspended National Police Commissioner, General Fani Masimula, and the others in this particular matter, which simply means also that anything that was discussed in that plea agreement and that damning affidavit, which we understand is containing the names of senior or higher-ranking police officers, that falls completely flat. That cannot be used by investigators. They'll have to start from scratch in terms of their investigations, and any details that may have been agreed to in this plea agreement simply means it's all now null and void.
Well, that's a breaking news story at the moment. And of course, thanks so much to Griselda Lewis, who's at the court for us. And it's been an interesting turn of events, given, what was said in handing down his recommendations, Magistrate Ignatius Dupree. He felt Kat Matlala didn't show any remorse. He felt he was taking the deal that was given by the state for his personal interest, given that, of course, this was a more lenient sentence that he believed was contrary to serving justice, which he also said needed to be seen by the public to be done.
Why do some people seem to attract luck, opportunities, and protection, while others struggle no matter how hard they try? It's not about talent, it's not about money, and it's not about destiny being unfair. There's something else, something invisible, something most people will never know. Since the day you were born, a guardian angel was assigned to you. He's been watching over you, trying to guide you, trying to protect you. But here's the truth no one talks about. If you don't know his name, he can't fully reach you. It's like calling out to someone in the dark without knowing who you're calling. The connection stays weak, the guidance stays faint, and the doors that should open stay closed. That's why some people feel stuck, not because they're cursed, not because they're unlucky, but because the bridge between them and their angel was never activated. My name is Angela. For over 40 years, I've been communicating with the angelic realm, and today I've been guided to reach out to you specifically. Your angel wants to change this, right now. He's ready to reveal his celestial name to you, the name only you are meant to speak. He also wants to give you a secret invocation, a sacred phrase that will let you call him to your side whenever you need him, day or night. Imagine what could shift in your life once that connection is fully open. The protection, the clarity, the obstacles finally moving out of your way. But I have to be honest with you. This window won't stay open forever. The energy that brought you here is rare. If you ignore it, it may not come back. I've seen too many people miss their moment. Don't be one of them. Click below to receive your angel's name, his personal message for you, and your secret invocation, so you can finally unlock the connection that's been waiting for you all along. Your angel is ready. Are you?
This isn't just any chat, it's ClickUp chat. Sure, you can tag your team, ask questions, and even drop an emoji. But the real magic is how it connects to the rest of my work. I can tag a task, a doc, or a whiteboard, everything I need in one place. This goes both ways. Chats can also be referenced inside tasks to let people join in on the fun. A chat might be connected to a project, so I can see my lists, dashboards, and docs side by side, making it effortless to reference what I need. If my boss has an ask, I can turn his message into a task instantly. This will automatically include the full context and link so no one gets lost. And get this, I don't even have to do it myself. My AI agent can create the task for me if I happen to be away. When chat is connected to the rest of your work, magic happens.
morning, Ms. Sildo.
Good morning, Chair. Today we continue with the IDEC stream, but Chair and Commissioners, perhaps it might be appropriate for the legal representatives of IDEC to place themselves on record. But before we commence, I have a request to make to the Commissioners. Thank you.
Good morning, Mr. Bodlani.
Good morning, Commissioners. I confirm I represent IDEC together with my colleague, Mr. Ramatsekisa.
Thank you.
Thank you, Chair. Before the first witness comes in, Chair, may I request a 5-minute stand down to address some issue that has arisen. I would benefit from an opportunity to do so. It should take not an inordinate amount of time. 5 minutes should be sufficient.
And you are not taking us into your confidence at this stage as to what it is. We'll hear when we come back.
If I may, with your leave.
Oh, all right. I will not indicate a time. You'll just call us in when you are ready.
Absolutely.
Mr. Bodlani, is that in order? Thank you. Let's adjourn then.
Thank you.
Thank you.
Jacques and Jill have come up the hill to talk about her savings.
Yeah.
That was a price that you couldn't believe.
I couldn't believe. I still can't believe, hey? 471 rand. I never used to afford nails, but now I go and do my nails.
Yes, please. So what would you say to the people out there?
Get Outsurance as soon as possible. Extra pampering money.
Go to outsurance.co.za now for a 10-minute quote that could save you thousands.
Please, Grandpa.
Yes!
Yay!
Your life is shaped by the moments that move you. The ones that matter most. The moments that make you feel alive. Part of who you are. The ones you want to keep saying yes to. Protect your freedom to move today and tomorrow. Keep saying yes to the moments that move you.
Yes.
With OsteoEase, South Africa's #1 joint care brand.
Running creative intake is easy because I use ClickUp. Here's how I do it without chasing down incomplete briefs. When requests come in incomplete, and they always do, I use an AI super agent to review the task and flag what's missing. It instantly tags the requester so I get the right details before the work starts. Once it's ready, I generate a complete creative brief that goes straight to my intake list. From there, it's automatically assigned and scheduled into the right designer's workflow. The reviews, comments, and approvals, they all happen in one place so nothing gets lost. ClickUp makes creative work easy, so my team can focus on creating, not chasing details. Click the link below to create your free workspace.
Ms. Sillo.
Thank you, Commissioners, for the indulgence. We have conferred, and I'm ready to engage the Commissioners. Commissioners, for the record, the next witness for appearance today was scheduled to be Advocate Andrea Johnson. She unfortunately will not be available today to testify, and her counsel is ready to address the Commission on the circumstances leading to this state of affairs. Thank you, Chair.
Thank you, Ms. Sillo. Yes, Mr. Bodlani.
Thank you, Commissioners. Shortly before my arrival on the venue this morning, the representative of the client received a telephone call from one of Advocate Johnson's protectors informing us that she is not able to be with us. They are rushing her to hospital. I don't know what has happened.
This happened this morning?
This happened this morning as we were on the way to the venue. And then during the adjournment, only then were we able to get a sick note or a medical certificate from her doctor. But the client's representative were able to talk to the doctor shortly before we convened, before the adjournment we had this morning. And we were made to understand that she is with the doctor. She had some serious health-related issues that I'm not able to disclose in public, and that she is being attended to. The medical certificate in our possession indicates that she is not well, at least between today, the 13th of July, 2026, including the 15th of July, 2026. I do accept that this affects the conduct of the affairs of the Commission because the Commission had its own agenda, its own program for the week. But the circumstances are such that, as my colleague Ms. Sillo has indicated, the Commission would not be able to conduct its business today in circumstances where the person who was scheduled to be here is not able to be here.
Thank you, Mr. Bodlani. I think at least twice you referred to the representative of your client. Who are you talking about?
That would be Mr. Maga.
Or from the NPA?
From the NPA, yes.
Oh, all right, I understand. Thank you very much.
Chair, for the record, we have been provided with a copy of the medical certificate, and I think copies have been made for the commissioners. I beg leave to hand them in for the record. And then, in light of the fact that the witness is unwell and is only being attended to today, I would request that the commissioners postpone her appearance to a date to be determined. I fear that if we fix a date, a specific date, we may be back before you to seek a further postponement because she is still indisposed. That is my suggestion, but we are in the Commissioner's hands.
Thank you. I noticed that this is one of those medical certificates, the nature of which I've previously said are useless in the sense that they give no information whatsoever. It's not even a case of what Mr. Bodlani said, which is confidentiality issues. It's just one of those useless so-called medical certificates.
Indeed, Chair.
But anyway, the bottom line is that Advocate Johnson is not here.
Indeed.
We are forced in the circumstances to postpone the hearing of Advocate Johnson's testimony to a date to be determined.
Thank you, Chair.
Thank you.
Ouch. Yo. Shame. Oof.
Something we discussed as commissioners was perhaps whether there is a way in which you could explain, but of course in my own head I think I already know why not, but a way in which you could explain, perhaps for the benefit of the public, because the public may be wanting to know why are they not proceeding in the same way they did with Mr. Mike van Wyk, the same way we did with General Khan.
Yes,
why not in this instance? But as I say, I think I know why. In fact, it's not even thinking, I know why.
Thank you, Chair. I was going to address the commissioners on that, to say that we do appreciate that the Commission is operating under exceptionally tight timelines, and we considered the possibility of, quote-unquote, saving the day so that the Commission sitting doesn't collapse entirely today. We considered that as an option, but ever so fleetingly, because the nature of Advocate Johnson's testimony does not lend itself to that kind of approach. The examples that the Chair has provided all relate to WhatsApp messages that are written, have been provided to the witness, and on the basis of which the witness would be asked questions and the witness would respond. So that allowed the evidence leaders to place that material on record without the witness, reserving, of course, the witness's right to come back at a later stage and respond thereto.
Also with the evidence leaders drawing inferences as they went along,
yes,
on what they make of the chats.
Indeed.
Yeah.
What I have are two statements, a statement and a supplementary statement from Advocate Johnson, both of which are narrative in nature. I don't have WhatsApp messages to engage or to share with the commissioners, and the only option would be to read her statements into record. But her statements are responding already to questions already posed. So at best it would require me to go find the question and then read for you what she says, where she can sit in the witness box and give the narrative as she has set it out in her papers. So I would argue, Chair, that the nature...
And that would not serve much purpose. Indeed. Because we would want to engage her or probe her on the narrative that she gives. So it just would not work. Yeah.
Especially because I'm sure as the commissioners have prepared on the basis of the very statements. So to have the statements read back to you that you've already applied your minds to without the ability to engage, because you can engage me on them, I think wouldn't serve much of a purpose.
Yeah.
So my short response would be, unfortunately, the nature of the testimony of Advocate Johnson doesn't lend itself to that option. We do not have a filler witness that we could immediately present to you. And unfortunately, we find ourselves in a place where we simply will have to postpone a hearing today. Thank you, Chair.
Thank you. So do we resume at 9:30 tomorrow?
Yes, we're ready to resume at 9:30 tomorrow.
With another witness?
Yes, Chair.
Let's adjourn and resume at 9:30 tomorrow. You are excused, Mr. Bodlani. Thank you.
Thank you, Chair.
To be a pet parent is to be human. Sometimes we feel guilty, even when it's for their own good. It's not always a walk in the park. That's why more and more pet parents rely on Hills, with scientifically proven formulas to give more love than humanly possible. Because you're only human, there's Hills. Science does more.
So, there we go. I'm hearing something. Stone, wherever he laid his head was his home. Which I'm the first grandchild. There's no other that has emerged. So I am still holding that title. But good to see you, big bro.
Good to see you, Tumi. We are here finally.
We're here finally. You know what? I know that publicly you've been asked, when is your podcast coming out? Even
God.
other podcasters.
Yes.
What is going on? Why are we here? Because me and you are mainstream. What are we doing here?
Look, I mean, you can see there's nothing in our ears. So nobody's telling us what to think, what to say. And that's exactly how it's going to roll.
Yeah.
Right? And really, this whole issue is about adding a voice to the freedom of expression. And I'm going to talk a little bit about that.
Yeah.
Right? But we thought, there's so many podcasts, why another one? And I think it's summarized by one sentence. Leave no one behind.
Right.
You and I may take it for granted that I can listen to an 1 hour podcast, maybe the 2 or 3 of them, and so on, and the data doesn't matter. But if I live in Alex, and I have to choose between buying bread and milk and buying data so I can listen to you for an hour,
yeah.
If I'm unemployed and I'm downtrodden, I'm likely to choose first what will make me survive.
Right.
And then information consumption would then become a luxury. To be an added extra. So we thought, well, let's take, like we are doing today, 10 community radio stations and connect them to the podcast. So
Right.
that the podcast is not just about the YouTube, but about an ordinary person sitting in Deep Kloof, listening to Josie FM.
Yeah.
Right? But doesn't have money for data, but can switch on their radio station.
Right.
And also follow. And we will, as much as possible, try and pull that together. Hence also our partnership with Sunday World. They're already having 2 million digital followers. So already we're saying Sunday World plus 10 community stations plus Frank Dialogue podcast leaves no one behind. Right? While at the same time, putting a cement on freedom of expression.
Yeah.
So that you don't have people somewhere in the background, somewhere deciding, or those who criticize Zuma, please stay away. Or those who criticize Ramaphosa, don't say this here.
Right.
And whatever else.
So in essence, what you're saying is some of the most influential, powerful thought leaders, shapers, may not necessarily have an opportunity to go to Kofifi FM, so that community can have proximity to them.
It's not even about the opportunity.
Yeah.
It's about their attitude. If you say to a minister, and you ask any spokesperson to say, let's go to Kofifi FM, you say, what? Kofifi?